Good morning and welcome to this Landmark Chambers webinar on the Supreme Court's judgment last week in AM Zimbabwe concerning the circumstances in which the removal of a foreign national would be in breach of Article 3. ECHR, we're delighted to see so many of you participating in the webinar today, and it's great to be able to discuss the judgment with you while it's still hot off the press, having been delivered literally 1 week ago. My name's Charlie Banner. I acted for the Air Centre in the Supreme Court in AM Zimbabwe, and I'm looking forward to sharing some of my insight from it with you. Before we begin, a couple of housekeeping points. Firstly, if you lose your connection, please just log back in with the same details. They'll work again. Secondly, the default mode, at least, is that your cameras and microphones are automatically switched off. Never quite sure if that's for your benefit or ours, but anyway, I hope that provides you with some reassurance. Now, let me introduce the other two panelists, both also of Landmark Chambers. For many of you, I'm sure they won't need an introduction, but for some of you, they might. Philip Nathan is a highly experienced specialist in asylum and immigration law with a hugely impressive case list covering the whole range of work in this field. Yaaser Vanderman is a public law and human rights specialist with considerable experience of Supreme Court litigation, including in AM Zimbabwe, where I was fortunate to have him on my team. One of the 4 cases in the Supreme Court he appeared in last year. Philip will start off by outlining the case law preceding the Supreme Court's judgment in AM Zimbabwe. Yaaser will then explain what the Supreme Court decided, and then Philip will pick up again and explore the implications of the Supreme Court's judgment for other cases going forward. There'll be time for question and answers. We'll do those at the end collectively, so please do provide any questions and comments in the Q&A box that should be, I think, on the bottom of your screen if your format of Zoom is the same as mine. We might not have time to answer all the questions during the webinar, depending on how many we get, but we would endeavour to be in touch by email afterwards to address any outstanding themes that arise out of the questions and comments received that we didn't get to deal with. Before I hand over to Philip, I'd just like to offer a few comments of my own from the perspective of having argued this case. As many of you who've read the judgment will appreciate, the crux of the Supreme Court's judgment was to recognise that the European Court of Human Rights judgment in Papashvili extended the categories of seriously ill people whose removal would be contrary to Article 3 on account of non-availability in the treatment in the receiving state, from the deathbed paradigm of the D case, which was the only category previously recognised, to include a considerably wider range of cases, the precise nature of which Yaaser will explain, as well as outlining the procedural and evidential principles applicable to such cases. Now, the first-time reader of the judgment might be forgiven for thinking, well, wasn't the real groundbreaking case Papashvili rather than AM? And on one level, that's right. But the real challenge in the Supreme Court was that the Court of Appeal had read Papashvili in a highly restrictive manner, holding that it represented only a very modest change and the imminence of death in the receiving state was still necessary to engage Article 3. So the debate in the Supreme Court was really about how the European Court's judgment in Papashvili should be read and interpreted. And in particular, the appellant in the Air Centre argued that it was an unwarranted gloss on the language used by the court, the European Court, to read the judgment as requiring that imminence of death in the receiving state was still required to engage Article 3. And as Yaaser will explain in more detail, the Supreme Court agreed and went on to hold that the House of Lords' previous judgment in the N case should be departed from, as it was inconsistent with the new test in Papashvili. Now, whilst the departure from M was on one level a formality once the full extent of Papashvili had been recognised, persuading the Supreme Court to depart from the tightly argued judgment of Lord Justice Sales in the Court of Appeal was by no means a formality. And in my view, actually the most important comparison, certainly the most interesting one in understanding the Supreme Court's judgment, is actually not between N and AM Zimbabwe, but actually between the Court of Appeal and the Supreme Court. And that was to my mind, is where the Supreme Court's judgment truly was groundbreaking. Now, with that, I'm going to hand over to Philip to commence the slides. So, Philip, over to you.
I hope people can see me, because I can't see me. Right, I've had a yes from Yaaser on WhatsApp. I can't see the slides or myself, but as long as you can see me, I guess that's what matters. I hope that you're all keeping safe and well during the lockdown. I've practiced in immigration and asylum for some time, and over the years, one can become fairly cynical about cases, even asylum cases. Health cases are different. I would imagine that even the most cynical among us will have had sleepless nights about these type of cases. I suspect Yaaser is all too aware of my own anxieties about my kidney dialysis case currently pending before the upper tribunal, given my campaign of harassment, perpetually asking since January, when is the AM judgment coming out? Well, I'm glad to say finally we have it, but before we look at AM, let's just look back a little bit first. The legal difficulty with health cases has persisted virtually since I returned to the bar in 2003. Following the 1997 success in D against the UK, where a St Kitts national successfully resisted his deportation owing to the late stage of his AIDS-related illness, the legal landscape has remained bleak until this new judgment. Broadly, every leading case has brought disappointment. In particular, first N, and then GS India, and even AM in the Court of Appeal. The decidedly morbid ratio of N was summarised effectively by Lord Justice Laws at paragraph 66 of GS. These citations demonstrate that in the view of the House of Lords, the D exception is confined to deathbed cases. Miss Leven submitted that the focus of their lordships' reasoning, at least that of Lord Nichols, was upon those with AIDS, a condition much more often suffered than end-stage kidney disease, so that the strictures in N should not be taken to apply to the latter class of case. But that would be merely adventitious and therefore unprincipled, and I can find nothing to support it in their lordships' speeches. I've suggested on the slide some shafts of light. In truth, these were little more than slivers. At paragraph 70 of GS, Lord Justice Laws suggested that to deny a sufferer of end-stage kidney disease an imminent life-changing transplant likely would breach Article 3. Similarly, in CA in 2004, he stated at paragraph 26, "It seems to me obvious simply as a matter of humanity that for a mother to witness the collapse of her newborn child's health, and perhaps its death, may be a kind of suffering far greater than might arise by the mother's confronting the self-same fate herself. There is no perversity in the approach taken by the adjudicator." Ultimately, the Article 3 case law was undeniably tragic. Colin Yeo's Free Movement blog, while commenting recently on the Supreme Court's judgment, noted that apparently N was removed to Uganda and died a few months later. The 4 claimants in GS India never received transplants, and apparently all have since died. Ironically, D, whose case was won on the basis that he, unlike the others, was on his deathbed, is, I believe, still living in the UK, having been successfully treated with antiretroviral medication which was not so well understood in 1997. Fortunately, things have improved with this one paragraph. Papashvili, paragraph 183, a small paragraph that seemed to open Article 3 to cases other than deathbed cases. Yaaser will explain its significance in a moment. As we can see, though, from the next slide, which I'm hoping my assistant will flick through to shortly, Yaaser, incredibly, it has taken 4.5 years for UK jurisprudence to catch up and follow Papashvili. In EA, the upper tribunal, understandably, correctly, applied precedent stating that they were bound by N. But rather than seek a leapfrog appeal, remitted the 2 live cases before them for further hearing by the FTT. The then Lord Justice Sale's judgment in AM in the Court of Appeal in January 2018 was a major surprise. Had we all misread Papashvili? Yaaser will now explain how the Supreme Court were persuaded to overturn one of their fellow learned justices for the second time in 12 months. And before I pass to Yaaser, perhaps spare a thought for poor Lord Justice Patton, who, with the immortal words, "I agree," followed Lord Justice Sales in KV Sri Lanka, and with the extra word, "I agree also followed his lordship in AM Zimbabwe. But anyway, over to Yaaser, who will explain the Supreme Court's judgment.
Good morning, everyone. Yeah, thank you so much, Philip. Hopefully my slides are there now. Yeah, okay. So now, on the day when the judgment came out, which was last week, I made a bit of a mawkish statement saying that when I was at university, I'd studied N, which had just come out, and how surreal it was to be playing the smallest part possible in the Supreme Court case that overturned it. Now, that was a bit sentimental, but I like a good fairy tale, and every good fairy tale needs an antagonist. Enter the Court of Appeal. Now, if you read Papashvili and then the Court of Appeal judgment, as I'm sure many of you have done, it's quite a roller coaster ride. The Court of Appeal essentially turned the wording used in Papashvili on its head so as to produce a result that was only a very modest extension as it expressed. Now, there was an obvious reason for this, the policy concerns, and those policy concerns have been expressed in the older cases. If you look at N, and reasonable people, I think, can disagree about policy pros and cons of the approach. But the difference here was that the Court of Appeal was changing the meaning of Papashvili in order to bend it to the policy objective. And that formed part of my Charlie submissions in the Supreme Court, i.e. Papashvili says what it says, let's recognise that, and if you don't want to follow it, that's a different argument, and we can argue about whether and in what circumstances the Supreme Court should be following Grand Chamber judgments. But the reason the Court of Appeal was able to do this was because the Grand Chamber wasn't as clear as it could have been. It did admittedly say that it was only clarifying the previous approach. It did not say that expressly that N was wrongly decided and was now being overruled. And that led it to come to the new test that it said Papashvili represented, which was that, yes, Article 3 is not confined just to deathbed cases. And the new test includes whether there's a real risk of being exposed to serious, rapid, and an irreversible decline in the state of health, resulting in either intense suffering or a significant reduction in life expectancy. Now, that wording is important because the last bullet, significant reduction in life expectancy, was said by the Court of Appeal to be contingent upon a serious, rapid, and irreversible decline. And you can see how that would reduce the acceptable reduction in life expectancy window that you might need to get through to the Article 3 threshold. And it took that test from, if I just go back to the wording, this is the wording. If you look at the last few lines, we'll see how the Supreme Court interpreted it. But one would think that looking at those last few lines, the last line, or to a significant reduction in life expectancy, was its own clause and wasn't connected to the serious, rapid, and irreversible decline in his or her state of health resulting in intense suffering. But that's not how the Court of Appeal interpreted it. Lord Wilson and the Supreme Court unanimously overturned that approach, saying it was wrong. And in argument, Lady Hale said, yes, the Grand Chamber didn't expressly overrule N, but that's simply not the way that it does things. So perhaps it wasn't surprising that it hadn't said that. And they disagreed with how the Court of Appeal had got to its strained interpretation and repeated the new test as set down by Papashvili in the following terms, so that one has to prove there are substantial grounds of a real risk of being exposed to either a serious, rapid, and irreversible decline in the state of health, resulting in intense suffering, or to a significant reduction in life expectancy. That last clause, significant reduction in life expectancy, being a standalone test, not being contingent on rapid and irreversible decline in the state of health. What is perhaps most surprising about the judgment is the lack of any reference to policy concerns. Now, on one view, you could say that's the way it should be, because Article 3 is an absolute obligation and does not and should not admit of justifications by the back door. But the reality is that the House of Lords did agonise over that issue in N. The courts have agonised over that issue, including the European Court of Human Rights, these issues. And so not to tackle them or really mention them in this judgment is significant. So what does the new test now practically mean? And this is the important bit for all practitioners who are going to be litigating these points in the courts. And no doubt they will be litigated over a lot in the tribunals. Lord Wilson did provide some guidance, which I think claimants will particularly pounce on. What does significant mean? It means substantial. So when one talks about a significant reduction in life expectancy, that means substantial reduction in life expectancy. And it's always going to be highly fact dependent. So facts of the case will depend. Whether Article 3 case succeeds will obviously depend intensely on the facts. What does death in the near future mean? Death in the near future is more likely to be significant, suggesting that even death in the near future may not be necessary to succeed in Article 3. But in any event, what does death in the near future mean? He gives an example, Lord Wilson, suggesting that a relatively young person, 24-year-old, losing 2 years of their life, having only 2 years of their life left, may well be sufficient for the Article 3 threshold, as compared to someone who is older, perhaps. And Lord Wilson uses the example of someone who's 74 years old. Now that's a really important statement, because there are many individuals who would only have had a few months to live without treatment. I'm thinking Mr. Papashvili himself, who had around 6 months to live previously, and also in N, I think the individual had a few months left to live. Previously, those would not have been sufficient under Article 3. So the suggestion by Lord Wilson, which I'm sure claimants will pounce upon, that 2 years might be sufficient, might well be sufficient for a young person, that's significant. And of course, it will depend on all the circumstances. Now, is there any comfort at all for the government here? A little bit, not very much at all. But in paragraph 32, Lord Wilson does, as you might expect, emphasise the demanding nature of the test. He says, let no one imagine that the test represents an undemanding threshold for an applicant to cross, for the requisite capacity of the evidence adduced by the applicant is to demonstrate substantial grounds for believing it is a very exceptional case because of a real risk of subjection to inhuman treatment. So he suggests that it is a demanding test, but of course, that doesn't take away from the examples and the detail he goes into as to what death in the near future means. So little, but not much comfort for the government there either. Perhaps of even greater practical benefit for claimants is the new procedural steps. Well, one might ask, is it that much different to what went before? The answer, I think, is yes, 100%. Previously, where there was a degree of speculation as to the impact of removal on health, that would count against the applicant. The applicant had to prove the extent and speed of deterioration, as well as the amount of treatment in a receiving country. As well as that, the theoretical availability of medical treatment was sufficient, notwithstanding that in practice you might not be able to get it. And that was, both of those propositions were held in N. But now, following Papashvili and AM Zimbabwe, the degree of speculation counts in the applicant's favour. You don't need to show clear proof. We'll come later as to what needs to be proved by each side, but you don't need to show clear proof of those things. And in addition, theoretical availability is insufficient. The real question is, will the applicant actually be able to get the treatment when they go to the receiving country? Ultimately, the following procedure will be used. You can see that I've split up into 3 steps, and that's what the Supreme Court did. Just word of warning, not all of the detail is in the Supreme Court judgment. So I would recommend going back to the various paragraphs in Papashvili, which looks at it in more detail. But the first step is that the applicant must raise a prima facie case of potential infringement of Article 3. And that means evidence capable of demonstrating substantial grounds for believing breach. And in Papashvili, they went in, there was some more detail on that. and they were content in that case to accept evidence of treatment in the receiving country was not without some credibility, or there was no guarantee. So a relatively low threshold there compared to what's gone before. And then once that's been proved, a prima facie case, you move on to step 2, and the burden shifts to the state. And the state must now dispel any serious doubts as to the availability and accessibility of suitable treatment in the receiving state. And in Papashvili, again, it said the state has to look at the general and specific situation in the receiving country, cost and proximity of the treatment, the existence of family network, etc. Previously, those things would have had to have been proved by the applicant. And the third step is that if doubts persist, then the state must receive individual and sufficient assurances from the receiving country. And by the way, there is reference in the Supreme Court judgment to a judgment of the upper tribunal in the AXB and Secretary of State case at the end of paragraph 32 of Lord Wilson's judgment. And that case was decided just before the Supreme Court hearing. And I raise it now because there the UT does look at the procedural aspects of Papashvili in detail. One word of warning about the upper tribunal judgment. I think we argued that for the most part it was consistent with Papashvili, but we did argue that there's one paragraph in AXB, paragraph 113. We argued it was incorrect to the extent that it said that N and Papashvili were consistent in their treatment of what a certain degree of speculation meant. As mentioned before, our view is that although the same wording may be used, whereas that used to count against the applicant, it now counts in the applicant's favour, so that no clear proof is needed. And it's fair to say the Supreme Court, that was our argument, and the Supreme Court didn't reject or endorse that point. It endorsed particular paragraphs of the XB judgment, but not 113. Now, Philip is in a moment, going to look at future implications of AM Zimbabwe, but technically, as Savran in Denmark was decided before the Supreme Court decision, albeit after Papashvili, it falls within my jurisdiction. Savran gives you the clearest example of how Papashvili has transformed the law in this area and how AM Zimbabwe might do the same domestically. You'll see in Savran, the court did apply the Papashvili test, and it found a breach of Article 3 on the following facts, which was that Mr. Savran had paranoid schizophrenia. His medicine included having clozapine daily, as well as risperidone fortnightly. And importantly, significantly, both of those drugs were available and free in Turkey, which was the country he was being removed to. But in addition to that, because of his condition, he also needed a regular contact person as well as an overall package of supervision. Otherwise, the fear he would relapse and would exhibit dangerous tendencies and become dangerous to the wider public, himself as well. Crucially, though, the court said there was no evidence about those elements being available in Turkey, as well as there being no family network for Mr. Savran in Turkey. And for that reason, they found a breach of Article 3. Now, there was a very strong dissent by 3 of the judges in that case who were in Papashvili, and they said that that was pushing the Article 3 door wide open. And in particular, they asked rhetorically which element of the test that we've just looked at was satisfied. Was there a significant reduction in life expectancy, or was this the other part of the test about a rapid, irreversible decline in health? And it's fair to say that the court in Savran didn't particularly examine in detail which part of the test was satisfied in Savran. And that was to the dismay of the dissentients, who said that that test had been very carefully delineated in Papashvili so as to keep the Article 3 test within narrow bounds. Now, that case has been referred to the Grand Chamber and will be heard at some stage in the next few months or a year. And the UK has applied to intervene, so no doubt there will be further word about Savran and whether that was going too far. But just think how quickly this case, Savran, would have been dismissed before Papashvili. And what the last word to say is that even if it is overturned by the Grand Chamber on its facts, it shows you just how far the dial has been moved since N, certainly since GS India, and since many cases since then before Papashvili. All right, I'm now going to hand back to Philip, who's going to talk about the potential future implications of AM Zimbabwe.
Thanks, Yaaser. I think if we can move to the next slide. I've made one major error in that slide, and can I just add also huge congratulations to Zayn Malik, Daryl Balroop and Sean and Co, who acted for AM both in the Court of Appeal and the Supreme Court. I've put the following two brief comments about the judgment in this slide. They can be read for themselves, but in relation to the Lord Brown, perhaps I could read from paragraph 90 of his Lordship's judgment in N. As already indicated, my clear understanding of the subsequent Strasbourg case law is that the court has now adopted a restrictive line. It has not been prepared to grant an absolute right to seriously ill persons to remain in the host country to get treatment, provided they had managed to set foot there. The very far-reaching consequences of such a right would give rise to positive obligations which the court has not thought it right to impose upon the contracting states. Now, as I say in the slide, while I'm certainly not complaining, it does strike me that neither the judgment in Papashvili nor the judgment in AM seem to offer any real explanation for the departure from that restrictive line. Moving on, where do we go now with health cases? And if my glamorous assistant could move to the, thank you. The legal climate following AM Zimbabwe is clearly far warmer, albeit that the judgment is anxious, as Yaaser has already related, almost at every step to reiterate the need for exceptionality. As for the preparing of cases, I'm likely stating the obvious, but solicitors will need to obtain as detailed reports as possible, setting out the precise treatment being received by the individual in the United Kingdom. That report will then need to address as well the consequences of any disruption or withdrawal of that treatment. Consideration will also have to be given to the need to obtain a report on the availability of affordable treatment in the country of origin, and if necessary, the relevant region of that country where the individual would be able to reside. In this respect, it should not be forgotten that in many cases, the Home Office COI reports will often have more than sufficient information to make that case, but if not, in my view, the legal aid agency ought to be easily persuadable to provide any necessary funding for expert reports. As Yaaser has pointed out, this is another critical game changer in Papashvili. Do remember poor Mr. Ben Said, for whom theoretically available treatment 80 kilometers from his home meant he could be returned to Algeria despite his serious schizophrenia. Theoretical but practically impossible treatment, i.e. owing to cost, geography or otherwise, is no longer on the table for the Secretary of State to justify removal. And I should say, while on the same subject, the Ben Said facts would also now fall within Papashvili and AM Zimbabwe. If one, as I've said in the second bullet point, it's serious physical or mental illness may now meet the threshold. Now, that seemed pretty clear from Papashvili, but it's abidingly clear now from the judgment in Savren in Denmark. And just one final point about Savren in Denmark. Yes, there was a very powerful dissenting argument on the facts, but actually the broad interpretation of Papashvili by even was stronger, if anything, in the dissenting judgment than in the main judgment. So while Savran may be going to the Grand Chamber, one suspects that not a great deal is going to change, and it will be more about the facts in Savran than anything else. If we can move to the next slide. Finally, I'm so sorry, actually, I should go back. The final point in AM Zimbabwe is the point about seeking reassurances, and there is scope for the Secretary of State to seek reassurances about treatments from the receiving state. No doubt the Secretary of State will seek to do this, but in many cases one suspects that evidence from those states will receive similarly short shrift by the UK courts to that given by the ECHR in Papashvili to reassurances that were obtained from the Georgian authorities. Now, in that regard, if one wants to look further, the critical paragraphs are paragraphs 141, 159 to 171, and 197 of Papashvili. Moving on, and noting that my time is almost up, can I just ask people to note very briefly in the next slide, MP against the Secretary of State in the Court of Justice of the European Union on the appropriate leave to be granted in health cases. Note the quoted passage, but ordinarily one's looking at discretionary leave rather than humanitarian protection. Do note also NO Afghanistan, where that claimant faced not only inadequate treatment for his adverse mental health, but also deliberate ill treatment in the form of exorcisms and beatings, such that a grant of humanitarian protection was in that case appropriate. Finally, the final slide, a brief word about Article 8. Prior to Papashvili, this was the only path to be taken in preventing removal in these type of cases. Nothing has changed with Papashvili, and the decisions in MM, Akalu and Parveen all remain good law and very helpful. Now, in the past, they were literally a lifeline to many previously. As he retired just after the lockdown, I'm going to send a shout out to Upper Tribunal Judge Craig, whose unreported decision in RK around the same time as the GS litigation enabled that appellant to go on and have a transplant and lead a normal life. Brave judges have been able to do great things with Article 8. However, the hope must be that many cases that previously had to rely on adverse health as a significant factor in the Article 8 balancing exercise will now no longer need to play the inevitable judicial lottery that is Article 8, and instead now will be able to win their appeals on the rather firmer ground of Article 3. Thank you very much for listening, and over back to Charlie, who I think will convene the Q&A.
Thanks very much indeed.
Thank you, Charlie.
And thanks, Yaaser, too, for those excellent presentations. We've got some brilliant questions. Thank you very much, and please keep them coming. We've got a few minutes left. I'm going to take the first one out of order because it follows on rather neatly from what you said a moment ago, Philip, about the Article 8 judicial lottery. Usman Sheikh has asked, do we think the tribunals will interpret the Supreme Court's decision in AM restrictively, closing the door that the Supreme Court's open, and if so, how? My own take on that is some judges might. I mean, plainly, there are some judges who take a more restrictive approach to cases like these and others, and the best possible illustration of that is, of course, Lord Justice Sales, now a member of the Supreme Court. Possibly the best thing for the appellants in AM was the fact that Lord Sales sat in the Court of Appeal and couldn't sit in the Supreme Court. And if he had, the outcome may have been, at least in relation to one judge, different. So plainly there's some scope for judicial interpretation. However, I think what's really important is the fact that the Supreme Court has made a very clear statement that the Court of Appeal's judgment in AM was too restrictive. And to my mind, that sends a pretty clear message that if there is any over-restrictive interpretation of the Supreme Court's judgment, then the tribunal or court doing that is likely to be reversed. The Supreme Court's not going to shirk at upholding AM unvarnished in the future. So possibly at first instance, but I think on appeal there ought to be a consistent approach. Again,
Charlie, can I add one bit on that?
Yeah.
Yeah, I mean, I think you must be right. And that's why I mentioned the Article 8 lottery, because there's so much wriggle room for judges on Article 8 to do what they want. And I think the judges are far more constrained now in relation to Article 3. And the roadmap that they've been given by the Court of Human Rights and the Supreme Court is pretty clear. So I would imagine it's going to be very difficult for the first tier or the upper tribunal to close that door.
Yes, I mean, perhaps subjective objective isn't quite the right terminology, but in a sense, there's the Article 8 considerations often come up tend to be a little bit easier to for individual judges to impose their subjective views, whereas the Article 3 issues arising out of AM are more objective, and perhaps there's less scope for a range of differing views. I can see that. Yeah, so the question which I wondered whether you might be able to answer based upon what you were saying earlier, Cornelius Katona has asked, as a non-lawyer, I wondered what the threshold was for a real risk. Can you elaborate on that?
I think that will be quite a heavily fact-dependent question. I'm not sure if that's the sort of, Philip, you can correct me if I'm wrong, but I'm not sure that there's a further legal gloss that you can put on that. There are quite a few cases like kidney issues and HIV issues and leukemia, which are often in these sorts of cases, if you think about N and D and GS India. And I think in those kind of cases, the real risk is pretty obvious, but there'll be other cases, I suppose, which are less prominent where that issue might be asked. But again, I'm not sure if I can really help other than say that it will depend on everyone's specific facts. Philip, do you?
Yeah, I mean, I was just going to say, I can see where it's coming from, Cornelius, because of course there's going to be with physical conditions like end-stage kidney disease or HIV issues. The consequences are going to be very clear, and I can see Cornelius is coming at it as a psychiatrist, where perhaps it's less difficult to predict the future. I think one has to remember that real risk, I think there's a case, it is a test that's applied in relation to asylum all the time. There was a case many years ago, I think an American case, that talked about a 1 in 10 chance of something happening. I'm not sure that really is quite the case, but it's still, real risk is a low threshold. But I think any psychiatric report saying that someone's going to be in desperate straits on return is going to need to be properly and significantly argued, set out, so that the courts are going to be able to look at it and think, wow, this really is a real concern going forward, and the real risk test is met. I hope that helps to a degree.
I agree. I mean, there's an associated question from Aisha Ahmed about could we expand it on how this line of case law might apply to mental health cases and risk of suicide or self-harm? Well, I mean, the first point is Savran has made very clear, if it needed to be made clear, that the principle applies to mental and psychiatric illness and not just physical illness. To my mind, the critical question applying the Papashvili AM approach is to look at the level, if any, of psychiatric care and treatment in the receiving state. And if, in light of the disparity, there's a real risk of being exposed to one of the two limbs, serious rapid and irreversible decline in state of health resulting in intense suffering or significant reduction in life expectancy, even if by the applicant's own hand, then the test is met. Where Savran, the court in Savran arguably went a bit too far, as it didn't tie in its findings about the disparities in psychiatric treatment between the host Denmark and the receiving state, didn't tie that in to then say, well, would those disparities lead to one of the two outcomes? And that's the leap of logic that's likely to be explored by the Grand Chamber. But I think that's broadly speaking how it should be applied. A further question from Shalini Patel, is it necessary for the individual to be actually getting treatment in the UK? That's a good question. I think in practice, yes, save in perhaps a kind of case it's quite hard to, certainly for me to conceive of, simply because part of the test for Article 3 to be engaged, even post Pappas-Vili, is a lack of appropriate treatment in the receiving state. And then that lack of appropriate treatment leading to one of the two outcomes, the two limbs referred to. And in a situation where no treatment is being provided in the host state, presumably because it's not needed, it's difficult to see how that test would be met, and in particular how resisting removal would cure that.
Charlie,
but you might think you might.
Yeah, no, it's funny. I was looking at that question. I'm thinking, well, but actually, I think in relation to physical ailments, I can't see. I think you're right. I can't think of a situation where someone's. I suppose maybe if they've got asthma that's triggered by going to a really hot country. That might, a really severe asthma, that might be applicable if that's where they're from and
exacerbated fact.
But equally, I suppose if someone suffers from has suffered in the past from terribly serious post-traumatic stress disorder in their country of origin, and that has been treated satisfactorily in the UK, so that they're no longer actually receiving treatment. I guess that it might be said that despite their recovery in the UK, the return to the trigger is likely to lead to rapid further deterioration. So I guess that might be another type of case that might fall.
Yeah, I can see the force of what you're saying there. So in other words, that it's where the return would itself trigger a need for treatment, which wasn't needed in the host state, and that exacerbating factor would then bring into play the Pappas-Vili AM test. I can see.
But I think even in those circumstances, in order to demonstrate that, you'd have to show that someone's received treatment in the past to get them to the point where they no longer need treatment.
I think we've got time for probably one more question. Lewis Martins asked, how widely will the term intense suffering be interpreted? And what type of case would realistically fall in that definition?
Charlie talking earlier about different judges taking different views, and I think that's one of those, what falls into that pot of different judges are going to take really different lines of what intense suffering means. It should be objective, but you can see the difficulties that would create. And that comes back to Philip's lottery of which judge you get. Yeah,
it's a very good question, and one that I hadn't thought of when I said what I said about Article 8, the difference between Article 8 and Article 3. Maybe that is where there'll be a lot of scope for judicial interpretation.
Yeah, and litigation, because it's plainly a point that hasn't yet been clarified. There was no definitive answer, even if a definitive answer is possible, which may not be, and so therefore likely to be tested. I agree with that. I think we've probably run out of time. I'm conscious that there comes a point where the webinar automatically ends because we run out of time. So as I said before at the beginning, we'll try and group together the questions that haven't yet been answered into themes and send out a note to participants which will come through your registration emails, will probably be Monday by the time that's done, given that Friday's a bank holiday. But we'll do that and capture, probably not question by question, but group them into themes and provide a short analysis, which we hope will be useful. Thank you very much indeed to Philip and Yaaser for your excellent presentations, and thank you all for participating. So really great to have so many people here, and thanks for some really interesting questions. And please do stay in touch, stay safe, and goodbye. Have a great day. Thank you very much.
Thanks all.
Thanks. Thank you.